All right, that is it. That is the defense opening statement in the case of Riley Gaul, who is on trial in Knoxville, Tennessee for the murder of his on-again and off-again ex-girlfriend Emma Walker, who was tragically shot right through the head. He claims, as you heard there in the defense opening statement, that this was all just a case of him trying to scare her and that he didn't intentionally want to murder her. I'm here alongside Jonna Spilbor, criminal defense attorney. Ooh, do you buy it, Jonna? Do you buy this? You don't.
This is going to be a tough row to hoe for the defense for a couple of reasons. Like, already I see them trying to mount a very technical defense, right? Where you really have to parse words of the elements of the crime and the jury instructions. And Rachel, whenever we have to do that with a jury, look, these jurors aren't going to be 12 lawyers. They're 12 peers from different walks of life, different professions, what have you. When you mount a technical defense, it can backfire on you as a defense attorney. Now, it's too early to tell when that's going to happen.
But at the same time, Jonna, I mean, if you think about the case here, what else in terms of you're the defense attorney, what else are you going to say? You certainly can't claim he wasn't the one that pulled the trigger, because, I mean, I just think the evidence for that is overwhelming. There's no way in denying that. So you're the defense attorney. This is really the only route, is the intention angle that you go for to try to prove that this guy was just a distraught teenager that was in love with this girl. The parents were trying to keep them apart, and he was doing everything desperately to get back together, and he loved her.
Which is a good point. And if you're going to have to raise this was just a terrible sort of heat of passion type move from this kid, then I don't want to sound disrespectful, then dumb it down. Like, just dumb it down. This was a teenage kid. They don't know how to act, right? Their brains, there's studies out there that say guys, until they hit the age 25, their brains aren't wired. Right, they're not wired the same. Like, keep it simple, stupid, is what I think they should, a better approach might be, if that were the case and he just couldn't control his impulse and he wanted to get her attention in the worst way, but he most certainly didn't want to kill her, ladies and gentlemen of the jury. I think that's a better approach.
Well, and that's kind of the approach the defense attorneys taken in that, you know, he was a bit irrational. He was staging, because they went through a couple, and we've talked about this and heard testimony in replays today, and actually some of the text messages where he staged a different scenario where he set up a kidnapping, and he used like I guess it was an app on a phone that disguised his phone number so he could send her text messages and really spooked her that he had been kidnapped. And I said this earlier to another guest I had on. I think that does kind of play into the defense's theory in all of this, that he's just this desperate hormonal teenager trying to do anything to get this girl back.
Right, and hopefully they might have some expert testimony to back that up, because what if there are parents, I'm not sure, you probably know, if there are parents on this jury of teenage kids, you know, not every teenage kid who's has unrequited love shoots inside their ex-girlfriend's house, right? There are other things you can do that are far less egregious. So maybe there's going to be some
this dude was emotional. Apparently, some of his friends said he was contemplating suicide.
Oh boy, yeah. See, it's a mess. He's an emotional mess. But it's not a leap. Like, anybody sitting in that box is going to say, look, there was a really good chance that somebody was going to get hurt if you shot inside a house where people were sleeping, especially if you knew that was her bedroom.
John, I want you to hold that thought right now, because I want to talk specifically about this hoax that we were talking about, this kidnapping hoax, where the prosecution says Riley Gaul sent these text messages using a disguised app to scare his ex-girlfriend or current girlfriend. It's kind of unclear in terms of what the relationship was, Emma Walker. And this is the testimony we heard earlier today from Max Bacon, a victim's friend. We're going to play some of that testimony. This is a recording from earlier on the day. In the meantime, I just want to let folks know they're not missing anything in court, that in fact there is a witness testifying, but that witness is a minor, so we aren't allowed to show that testimony. As soon as we get our feedback, we will take you live. In the meantime, let's listen to Max Bacon's testimony from earlier today.
Good afternoon, everybody. Welcome back to Law and Crime. I'm Aaron Keller. I'll be here with you for the afternoon as we continue to take a look at testimony in this Riley Gaul case out of Tennessee, a horrific case A teenager who was a football star who had gone off to college accused of murdering his cheerleader girlfriend. We've been in a bit of a blackout with court continuing live, but it's been the testimony of several minor witnesses that we have been asked, or rather ordered, not to carry live here on the network. So we've been looking back at the testimony of these other friends who did testify earlier. It looks like we might be getting a signal back any second, but Jonna Spilbor is with us. So we've got some of these friends, and we're getting a lot of detail about the relationship between the defendant and the victim here, and one of them is saying they both had strong attraction or feelings for one another. How does that ultimately play into whether or not there's guilt or innocence? It almost sounds like a lot of character evidence.
And it does sound like character evidence, and perhaps, look, we're dealing with two teenagers here, and the defendant that's on trial was a teenager at the time. You have to portray him as kind of, he's a kid, right? I mean, he's a kid. And this sort of thing shouldn't happen. This is such a sad and tragic case. And to the people in the jury box, you want to portray that this could not have been a premeditated, intentional murder because he was just a love-lorn child.
And that's the defense theory. We heard that during the opening statements yesterday. And interestingly, two of the stories, two of the cases we're covering right now have involved defendants like the one you see sitting there in the chair, the other, Sean Gray in Ohio, who both copped pleas either on the eve of trial, as this defendant did, or in the middle of it, as Sean Gray did. And it's an attempt to say, look, I did something wrong. I am guilty of something. I am just not guilty of the top charge. We're seeing that tactic twice in 2 days here.
Very unusual to see it at all, let alone twice in 2 days. But it's as if the defense attorneys are trying to take an X-Acto knife to the charging document here for strategic reasons, most likely, we think, to keep evidence away from the jury, certain types of evidence, which is very hard to do, Aaron, you know that. And some of this evidence has already been heard. And now jurors are going to have to say, well, wait a minute, do I get to analyze that, or do I not get to consider that? You know, it could be very confusing for the juries at the end of the day.
Well, look, I mean, ultimately, this is forcing the jurors to be legal technicians here to say, okay, look, it's not a question of fact. It's a question of what law plugs into the facts. And it's interesting, especially here in the Gaul case out of Tennessee, the one where we're expecting another witness to start talking any moment, and we'll bring it to you as soon as it happens. But look, they're forcing the jurors to really get into the weeds of the law here.
Yes, they most certainly are. And I don't know, are we supposed to be going in and listening to this testimony?
I could barely hear. I'm not sure whether we are or we aren't. I don't see the witness talking yet, but you know, it's forcing, as you said, the legal X-Acto knife, legal technicians on behalf of the jury. So we do have testimony beginning. Let's listen to court. It looks like another break here of some sort in the Riley Gaul case out of Tennessee. Again, the case of a former high school football player who had gone off to college at age 18, who's accused of killing his high school cheerleader girlfriend, ex-girlfriend, who was 16 at the time she died. This is kind of an interesting move. We're trying to figure out exactly why they called the defendant's stepfather and exactly what they're trying to introduce with these photos that they had. We didn't get a good look at them, but apparently there's something in there that the state wants to point out, and asked that stepfather if those photos had any business being in his house, and he said no. So we're both sitting here with bizarre looks on our face trying to figure out exactly what they're doing.
We are really scratching our heads. And the only thing I can think of, you know, not every witness is going to provide an aha moment, right? So whatever they're trying to attain from this, the stepfather, could be something that's just maybe forming a foundation for something that's to come, perhaps. And, you know, the other thing I find interesting is the stepdad, you know, I'm sure he wants to protect his stepson, but he's not. His affect is he's just calm, cool. He's not angry to be there.
He's taking his ooth seriously. It seems. Look, I mean, if you get called, you're going to get up there and tell the truth. Most people, I think 99% of people, 99.999% of people take their oaths very seriously. They're going to answer the questions asked in as honest a way as possible.
Right. So I'm curious to see what the cross-examination of this witness is going to be like, because, you know, like you and I were just sort of scratching our heads, like I'm not quite sure what they're trying to elicit from this person, but I guess we'll find out. That's the beauty.
Yeah, so as we wait for things to pick up in the case here, we've got a lot of moving parts in this case. You know, and trying to figure out where this part fits in. It may just be that they needed to get those photos introduced somehow, saying, look, they were found in your home. Did they have any business being there? Okay, well, what are they? Is the state just going to take them and then use them with other witnesses? And they just needed this guy to introduce them?
Possibly. I mean, we know that this defendant is facing more than just a murder charge, right? There are a lot of things that the prosecution has to, that they're going to try to persuade the jury on. So maybe this has something to do with the stalking or something to do with the aggravated, what were they calling it? Child abuse, which is kind of a strange count, but nevertheless. So it could have something to do with those.
Yeah, I mean, I wrote a piece trying to deconstruct the complaint, and it's up on lawandcrime.com for those of you who want to take a look at it. And it sort of breaks down exactly how they're trying to move through all of the charges here.
Right.
They're trying to use this child abuse to basically get to their version of a felony murder.
Yeah.
In other words, that he did something that, and I'm really boiling this down here, but he did something that injured or threatened to cause injury to someone who was under the age of 18, that counts as child abuse in that state. And then if a child abuse, which is a felony, results in a death, they can get to a murder charge that way.
It's interesting, though, because it's the same act that constitutes the child abuse constitutes what caused the death. So it's like 2 for 1 is what they're trying to get, I suppose. And it's very common for prosecutors to want, if you can charge a felony murder along with just a straight, whether it's first or second degree murder, it actually is a boon for the prosecution because you don't need intent. It's almost easier to get the conviction of the felony murder than it is sometimes than it is just a straight up first or second degree murder. And they're often charged that way, and I'm assuming that's why the prosecution did it in this case as well.
Yeah, I mean, look, here we've got the top charge, and we also have this charge. It's not dissimilar to what we saw in the Tex McIver case, which wrapped up not too long ago in Georgia. In a lot of states that don't have various degrees of murder, this is how they do it. They say, well, if you're involved in any of these other felonies and it results in a death, then it can be felony murder. They just have top murder, and then they have felony murder and all these other things underneath. And in New York, that's not the way it works here. In New York, there's a felony murder rule, but it's a very limited list of felonies that can apply. But New York has all these other degrees of murder.
Yeah.
I guess it gets you to the same place. It just gets there through a couple of logical somersaults that we normally don't see in other states. So that's how it could roll out here. While we're waiting for court to pick back up again this afternoon, apologize as to how disjunctive this is, but in a trial involving a teenage defendant and a teenage victim, there are a number of minor witnesses, and we have been told we cannot show them, nor can we carry audio from that testimony. It's why we have not been in court live very much today. One of the witnesses we could bring you earlier, though, was a witness named Zach Green. He's one of the victim's friends. Let's listen to his testimony. Okay, folks, that was testimony from earlier today, but it looks like court is about to pick up after about a 15-minute break in the Riley Gaul case out of Tennessee. The defendant sits waiting basically for witnesses to continue here. So, Jonna, we've got a little bit more detail about the stepfather's testimony, and basically it was about the black outfit that prosecutors allege that he wore when he was engaged in the crime of stalking.
Yeah.
And the father is basically saying, okay, look, I had this stuff in my house. It had no business being there. And that's what the photos apparently showed. So the defense, in the way that the defense is questioning all the witnesses of this mysterious man in black, who it looks like, if the state's case is true, that the defendant is the man in black.
Yeah.
Okay. The defense is trying to attack all that, saying, well, you weren't sure who it was. And is that really trying to raise reasonable doubt, or, which I know it is, or is it just kind of hurting the case? Because the defense is also saying that the excuse for pulling the trigger on the gun is that the defendant was trying to get the attention of the victim because they had been in a relationship and she started ignoring him. So it's like, at what point does the defense want its cake and want to eat it too here? They want both sides of this.
The defense also, at the end of the day, wants to make sure that they aren't incompetent in their representation. And so some of this stuff, you have to go through the motions, so to speak, so that when and if this is appealed, you have made sure that you've objected, you've gone down this road, you've asked the right questions, so that that may be an issue on appeal down the road, and that's probably what I don't think anybody is really contending that the black figure wasn't this defendant. In
Well,
fact,
the defense is.
It's part of this whole like bizarre series of behavior
Okay, so
leading up to this.
Look, if that's their theory, then why don't they just come out of the gate and say, okay, look, he entered a guilty plea of recklessly discharging the weapon. Mm-hmm. If they want to go with that theory, then to be intellectually honest, they need to turn around and say he also was the man in black and he's guilty of something in here as well. That's my thought. But anyway, let's go back to court live. We are at the end of the day in the Riley Gaul case out of Tennessee. This is the case of a high school football player who had just gone to college, who's accused of murdering his cheerleader girlfriend. Jonna Spilbor is here with me. Jonna, here the state was really zoning in on the exact elements the state needed. Was the bullet chambered?
Yeah.
They're trying to play into whether or not there was intent, because we heard the grandfather say, no, it wasn't. So the user of the weapon would have had to pull the slide back, chamber the round. In that time frame, we could have premeditation. I'm sure that's what the state's going to argue.
That could be one of the things they're going to argue. I think we actually went into painstaking detail about this gun. My heart was feeling for this grandfather because he doesn't want to be doing this. He has to be doing this. And, we don't know. Okay, so the grandfather says, I normally wouldn't chamber a round. Well, we don't know exactly when the round got chambered. Did it get chambered the moments before the shot rang out? Was the defendant playing with the gun prior to that and chambered it out? We don't know. Is it going to be the end-all, be-all of this particular case? No. There's so much more to unpack here, and I'm sure we'll get to that.
There is one last point I'll make, is the reason we got into such a debate there about the value of the weapon is that under Tennessee law, the punishment that the state can seek in a theft case, again, the gun under the state's theory was stolen from the grandfather, and he basically said his grandson didn't have permission to take it. The value of the weapon dictates the punishment. So that's why we saw that. And it's also why we saw the objection there, because that's what they're trying to get at there. So, Jonna Spilbor, criminal defense attorney, New York City. Great to have you back here on Law and Crime.
Always good to be here.
We're going to wrap up the day with my usual reminder that we are live from at least 9 a.m. until at least 5 p.m. Monday through Friday. We've got 4 cases on the docket for tomorrow. We have this case. We've got the David Copperfield civil case. We are also continuing to keep an eye on the Ohio case, Sean Great, where the defendant just happened to cop pleas to many, but not all of the charges against him right in the middle of his trial. My analysis about that is up on lawandcrime.com if you'd like to read it. Or closing statements, rather, in that case are expected on Monday. So we're not, I believe that's what I remember reading earlier. So that case might be on hold for a little bit. The defense really didn't put up a defense at this stage. No witnesses from the defense itself. So we're continuing to monitor that courtroom. And also, the Jeffrey Willis case in Michigan is back. You remember we carried his first trial related to the death of Rebecca Bletch, a mother in Michigan. That was in the end of last year, but his next trial is due to start any time. Jury selection has been grinding along. As of about an hour and a half ago, there were still 30 jurors to be questioned. Opening statements could occur as soon as tomorrow against Jeffrey Willis. In this case, he's accused of killing that gas station attendant, Jessica Harriga. You'll certainly want to tune in for that. For now, this is Aaron Keller for everybody here at Law and Crime. Have a good evening. We'll see you tomorrow.